The Supreme Court heard oral arguments today. Perhaps you were with us watching live. Pretty fascinating to listen to over whether former President Donald Trump is eligible to run for a second term in the White House. Colorado's Supreme Court barred Trump from holding public office based on Section 3 of the 14th Amendment. Now, it does not explicitly reference the president, but it does say anyone who participates in insurrection cannot hold office.
The former president is arguing that this does not apply to him or his conduct while in the White House. His attorneys also say if the Colorado ruling is upheld, it could have dangerous repercussions for elections across the U.S.
The Colorado Supreme Court held that President Donald J. Trump is constitutionally disqualified from serving as president under Section 3 of the 14th Amendment. The Colorado Supreme Court's decision is wrong and should be reversed for numerous independent reasons.
For the first time in history, the attack was incited by a sitting president of the United States to disrupt the peaceful transfer of presidential power. By engaging in insurrection.
CBS News chief legal correspondent Jan Crawford is outside of the Supreme Court. Jan, you were inside listening to these arguments. Justice Samuel Alito challenged the lawyer representing the Colorado's attorneys earlier about the potential national effects of this case. I just want to play that for our viewers and get your response on the other side.
Your reply brief says that it wasn't because I think you say it did not involve an organized attempt to overthrow the government. So
that's one of many reasons. But for an insurrection, there needs to be an organized, concerted effort to overthrow the government of the United States through violence. And this
so the point is that a chaotic effort to overthrow the government is not an insurrection?
No, we didn't concede that it's an effort to overthrow the government either, Justice Jackson. Right? None of these criteria were met. This was a riot. It was not an insurrection. The events were shameful, criminal, violent, all of those things, but it did not qualify as insurrection, as that term is used in Section 3.
All right, and as we heard there, that was Justice Ketanji Brown Jackson replying to Jonathan Mitchell, who is the attorney for President Trump. Jan, what did you make of that exchange?
Well, I mean, first of all, before we get to that and where she's going with that, because I think that's actually not what they're going to focus on at all in this opinion, whether or not Trump committed insurrection. They're not even going to get to that. I mean, this was an extraordinary 2+ hours of argument where you really saw the justices kind of playing off each other and the lawyers to try to come to some kind of agreement on what the words and meaning of the Section 3 of the 14th Amendment is all about. And I think at the end of this argument, what was clear is not if Donald Trump is going to win this case, but how. They seem to be organizing around one kind of primary idea, and liberal Justice Elena Kagan kicked it right off when she said, basically, how can one state determine who is going to be on the ballot for president and affect states across the country? This is simply not, under this section of the Constitution, anything that authorizes states to disqualify a presidential candidate. And then after she kicked that off, you had Justice Amy Coney Barrett, who is a conservative justice, saying, yeah, it doesn't seem like a state issue at all. You had the Chief Justice, John Roberts, saying other states would follow on this. And it might not just be other Democratic states trying to kick Trump off the ballot. You may see Republican states, he implied, trying to remove a Democratic candidate from the ballot. The chaos would ensue. And the attorney for Colorado voters tried to push back on that and say this has never happened. This is a one-off. But Justice Alito, to your point earlier, one exchange that I thought was very interesting said, basically, are you kidding me? I mean, this is a Pandora's box. If we allow different states to start kicking presidential candidates off the ballot, look what happened with impeachment. President Jackson was impeached. It took 100 years for another president to be impeached. That was a one-off, right, with Bill Clinton. But then after that, we've had 3, suggesting that if the court allows this now, it's Katie bar the door. You're going to see these kind of challenges throughout other presidential elections as well. So I think kind of where we come down on this right now is that this court very well could be poised to a unanimous decision saying that states simply do not have this power under Section 3 of the 14th Amendment to disqualify presidential candidates. That's something that's up to Congress. There is a mechanism for doing it. It's just not the one that the Colorado system tried to do. On Justice Jackson's point, They were talking about insurrection there, and she also made some really interesting other points about the words of the 14th Amendment, the text of it, the history of it, suggesting that it doesn't even apply to presidents at all. If you read the words, it doesn't say presidents. So why would we, in her words, kind of allow this ambiguity, as she put it, to essentially undermine democracy? I mean, that is about as powerful as you can get, and she is obviously one of the most liberal justices on the Supreme Court.
Very interesting hearing Justice Brown Jackson, I think, making that argument even more forcefully than we actually heard Jonathan Mitchell, Trump's attorney, make it during his questioning. But Jan, Errol and I were talking about how fascinating it was to listen to the justices, to hear their voices, to hear what they really pressed in on. And you have been in the courtroom on so many of these major cases. Talk to us. Give us the insight of what it was like to actually see their faces, to be there today. And I also wanted to follow up on a point that you were making about the difference between Bush v. Gore and the possibility in this case for the justices to even potentially be unanimous in their decision. And do you think that Justice Sotomayor might join a majority opinion in this case?
That's a good question about Justice Sotomayor. My guess is yes, although at the beginning of the argument, she asked a couple questions, and I was like, I'm not sure where she's going with that. But I thought what was so interesting about this argument and what was really different than some of the other ones we've seen in recent terms where, you know, this court is so divided. I mean, remember what happened when they overturned Roe versus Wade. But then even going back to different courts, Bush versus Gore, so divided. And you can feel that in the oral argument, right? Like you get the liberals who are like going after the lawyer for the opposing side, trying to expose holes in his argument. You have the conservatives kind of joining forces, going after the other lawyer. This was totally different today. This was very much a bench of 9 justices from very different ideological perspectives. You have liberals, conservatives, and then differences, and among those liberals and conservatives, all coming together and like trying to figure this out. Right? Like they were throwing things out there. What about this? And you guys listened to it. You could hear, Justice Barrett, conservative, saying, but I want to go back to what Justice Kagan, who's a liberal, said about this. So that was really fascinating. And that's not something you see at the Supreme Court all the time on a hugely significant case, and one that outside this court is extremely politically divided. So I think it's a real moment for the court, which they certainly punted on in Bush versus Gore, 5-4, conservatives giving the White House to George W. Bush and liberals siding with, Al Gore. This is a moment for the court to show that they can rise above politics and they can look at the words and the meaning and the understanding of an old Section 3 of the 14th Amendment and come together and say, this is what the law is, and perhaps be unanimous. Of course, I think that's what the Chief Justice would like, and it looked like from the arguments today, based on the way they conducted themselves, that's what they would like as well.
All right, Jan Crawford outside of the Supreme Court for us. Thank you, Jan.
Thank you, Jan.
Jessica Levinson is with us now. She's a CBS News legal contributor and a professor for Loyola Law School in California. I want to ask this question that Errol was getting at before about Samuel Alito challenging the lawyer representing Colorado. He asked about the potential effects of this case, and he brought this up multiple times, I think, in each line of questioning. Talk to us about the implications and how all of that is factoring in potentially to the justice's decision now.
So I think exactly as you heard Jan explain so clearly, that what we heard is it wasn't just Justice Alito, although certainly he kept coming back to this theme, but it was all the justices concerned about what happens in our constitutional system if we say one state has the power to disqualify a federal candidate. What does that mean to our ability for the voters to know whether or not they can vote for a candidate who is qualified or not qualified? I think what you heard Justice Alito and the other justices saying is, this is a place where we need to speak with one voice. This is a place where I think what they were coalescing behind is we need a congressional statute that tells the states, here's when you can act and here's when you cannot act. And yes, it was Justice Alito, again, who kept coming back to this point, but you heard the other justices, one saying, legally, do states have the power to throw one federal candidate off the ballot And you heard Justice Kagan, as Jan was mentioning, talking about that a number of times. But then, two, what type of chaos are we unleashing on the system if we say, each state, you have the power to make this determination? Now, I think Colorado made the best argument that they could have to say, we have power under the Constitution, and they were pointing not just to Section 3, but also to Article 2, talking about the fact that they do serve as a gatekeeper when it comes to ballot access. But I think what we heard, and we can talk about the details throughout the 2 hours, the 2+ hours of arguments, is that there is something different about this qualification/disqualification provision. And there is something, I think, in the justices' minds, worrying about saying to one particular state, have this power over a national, a federal question.
And so what does that mean then, Jessica? Because there was so much skepticism from the justices, including the liberal justices, that any one state has this ability based on the 14th Amendment and Section 3. The president specifically is not referenced, while every other kind of elected person is. So if we take that a step further and Colorado's ruling is struck down by the Supreme Court, what might the legal repercussions be nationally and in other states that have this same question?
So I think what we might be looking at is a Supreme Court decision that says we need Congress to act. We need Congress to say, states, here's when you can disqualify a federal candidate, and here's when you can not disqualify a federal candidate. Just wanted to pick up on something you mentioned about the wording of Section 3 and how there was, in the beginning, I thought, and now I've kind of changed my mind, but I thought in the beginning there was a fairly lengthy, and I thought potentially this is the path that the court's going to take, discussion about whether or not being a president, whether or not having held that office even triggers Section 3. And you heard Justice Ketanji Brown Jackson forcefully say, I'm looking at the history of the 14th Amendment. I'm looking at the fact that we were worried about state and local officials. I'm looking at that word officer in Section 3 of the 14th Amendment. And I don't think holding the office of president even means that Section 3 applies. And so initially I thought, oh, this is the off-ramp they're going to take. But then there was so much discussion about what we were just talking about before, that worry about saying that states can have this power, the worry about the practical consequences, that I now think maybe that's the off-ramp they take.
All right, Jessica Levinson joining us from Los Angeles.